This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk about one of the key terms in a liability insurance policy, and that is occurrence. An occurrence is usually defined as an accidental loss or damage which results during the policy period in bodily injury or property damage. In Green v. State Farm Fire, a 2005 decision of the Utah Court of Appeal, a homeowner sued the insured developer after he sustained property damages as a result of a landslide. At the time of the landslide, the developer held a contractor's builder's risk insurance policy issued by State Farm. The developer initiated a declaratory judgment action against State Farm, seeking defense and indemnification under the policy. The Court of Appeals held that the lack of a claim of simple negligence scuppered the developer's case. Under Utah law, the scope of the risk an insurance company takes is determined by the terms of the policy, not the expectations of the insured. Absent a finding of ambiguity, the Court of Appeals simply construed the policy according to its plain and ordinary meaning. In that case, construing the policy according to its ordinary meaning led the court to conclude that under the unambiguous terms of the policy, the complaint did not include allegations that constituted an occurrence under the policy. It should be axiomatic in all third-party liability cases that because there can be a duty to defend, there must be an occurrence or accident, so that the events sued upon are found to be fortuitous. In some states, the pleading controls the decision on coverage, as in Utah, while in others, like California, the insurer is obligated to look beyond the complaint to extrinsic facts. The 11th Circuit applied the injury in fact trigger 3 times in the context of similar occurrence-based CGL policies and latent damages for purposes of determining whether the damage occurred during the policy period or during ongoing operations. The court recognized that the 11th Circuit explicitly limited its holdings to the specific terms of the policy and facts before it. For example, in Liberty Mutual versus Treesdale, Inc., a 3rd Circuit decision from 2005, all asbestos claims were found to have been the result of a single occurrence, as used in the policy. From approximately 1966 to 1975, Treesdale manufactured and sold a product known as Sofalex, which contained asbestos. Several thousand asbestos exposure claims have been filed against Treesdale to date. The asbestos claims are typically filed by steel workers who worked in the open hearth part of steel mills and others who claim to have had contact with the open heart. Treesdale contended that all of those asbestos claims share a common feature: repeated exposure to asbestos and at least one exposure to Treesdale's asbestos-containing product. The 3rd Circuit applied, as it had in the past, the cause of loss test that it defined as follows, quote, "The general rule is that an occurrence is determined by the cause or causes of the resulting injury. The majority of decisions and jurisdictions employ the cause theory. Using this analysis, the court asked if there was but one proximate, uninterrupted, and continuing cause which resulted in all of the injuries and damage. Close quote. The Third Circuit in Truesdale found, applying a case called appellation, that the asbestos claimants' injuries stemmed from a common source, that is, the manufacture and sale of the asbestos-containing products, and that they therefore constituted a single occurrence. In a case of sexual abuse of a minor, where the minor plaintiff in the underlying action could only give a broad time frame in which the sexual abuse was perpetrated, the court concluded that proration of liability among the insurers insuring against the liability of the defendant over the years the abuse took place acknowledged the fact that there was uncertainty as what actually transpired during any particular policy period. Inherent in the plain meaning of accident or occurrence is the doctrine of fortuity. Indeed, the fortuity principle is central to the notion of what constitutes insurance. Although the term fortuity is used almost everywhere, in short, fortuity consists of two central aspects: intent and control. The concept of fortuity is inherent in all liability policies, so that a loss is fortuitous if it was not intended. A loss or harm is not fortuitous if the loss or harm is caused intentionally by the insured. For an event to be truly fortuitous, it must, of course, be accidental, because the policy only covers occurrences that are accidents. Of course, one cannot intend to commit an accident, because an accident is an event that takes place without one's foresight or expectation. In Automobile Insurance Company of Hartford versus Cook, a 2003 decision of New York appellate courts, the court was faced with the legal question of whether an individual's homeowner's insurance policy affords coverage when that individual is sued for wrongful death after killing a person in self-defense. On February 20, 2002, defendant Alfred S. Cook shot and killed Richard A. Barber, the decedent, after a disagreement over a business arrangement spun out of control. The decedent had entered Cook's home without permission. During their discussions, Cook, armed with a handgun, retreated to his bedroom to retrieve a 12-gauge shotgun and then returned to the living room where the fatal confrontation occurred. Cook was indicted for a number of crimes, including murder in the second degree. He stood trial and was acquitted on all counts of the indictment. The jury concluded in the criminal case that the prosecution failed to prove beyond a reasonable doubt that the 120-pound Cook did not have legal justification for shooting the 360-pound decedent who had previously attacked and injured Cook after he refused to leave Cook's home. Finding no coverage, the majority held there was no possible interpretation other than the acts were intentional. In a case where the policy language does not refer to an intentional act, but rather contains an exclusion that applies to assault and or battery committed by any insured or any other person, application of the exclusion does not depend on the perpetrator's mental state or whether an injured person was the intended victim. When the perpetrator was convicted of battery on the claimant, the exclusion applies regardless of the perpetrator's mental state. In 1978, the California Supreme Court, in a case called Clemmer versus Hartford Insurance Company, dealt with a shooting that resulted in the death of the victim. Regardless, it still led to a finding by the California Supreme Court of a need for Hartford to provide defense and indemnity. The court concluded that Hartford had no duties with regard to Dr. Lovelace's intentional acts in the killing of Dr. Clemmer, but was obligated to defend him. If there was a finding of non-intentional conduct in the shooting, however, it would also be obligated to defend, and if its refusal to do so would be wrongful, and it would be required to indemnify. One of the most extreme situations where an insured almost got coverage for an intentional act occurred in a case called State Farm versus Patrick Frake, a 2011 decision of the California Court of Appeal that reversed the trial court by concluding that an intentional act that causes injury, whether the injury itself was intended by the actor or not, is not an accident nor an occurrence, as those terms are used in a liability insurance policy. It thus concluded that the insurer neither owed defense nor indemnity. Under California law, the word accident in the coverage clause of a liability policy refers to the conduct of the insured for which liability is sought to be imposed on the insured. The term accident refers to the nature of the conduct itself rather than to its consequences. The insured's subjective intent is irrelevant to a determination of coverage. In cases where an intentional act is substantially certain to cause injury, determination of an insured's subjective intent, or lack thereof, is not conclusive with regard to coverage. Rather, an insured's protestations that he or she didn't mean to hurt anyone are only relevant where the intentional act at issue is not substantially certain to result in injury. Clearly, bad people do bad things. Forcing a woman to have an abortion, beating that woman and imprisoning her while threatening to kill her mother, cut off her fingers, and force her to act against her doctor's recommendations are all intentional and abusive conduct that is excluded by almost every policy. Even after pleading guilty to a domestic abuse crime, Nikos Hecht had the unmitigated gall, the total chutzpah, to sue his insurer for not providing a defense and indemnity brought against him by the abused woman. In Nikos Hecht versus Great Northern, a 10th Circuit decision from 2019, Hecht had pleaded guilty to domestic abuse, an act that was proved beyond a reasonable doubt. The actions of Hecht were clearly and unambiguously excluded. The allegations of the complaint, although it claimed some of Hecht's acts were negligent, the use of a Mexican nurse practitioner to attempt an abortion, those acts were totally intertwined with the abusive and intentional acts, so that the negligent acts were part and parcel of the intentional criminal conduct. Assaults, given their intentional nature, would seem never to constitute an occurrence under a general liability policy. However, courts have adopted two divergent positions as to from whose perspective the assault is to be viewed in determining whether it constitutes an accident. Some courts have held that this determination should be made from the standpoint of the injured party, while other courts have held that the determination must be made from the standpoint of the assailant, who is often, but not always, the insured. The Wisconsin Supreme Court, in a case called Schinner v. Gundrum, a 2013 decision, concluded that when an insured is seeking coverage, the determination of whether an injury is accidental under a liability insurance policy should be viewed from the standpoint of the insured. The court found that Gundrum's actions in setting up an isolated shed for a drinking party, procuring alcohol and expecting others to bring alcohol, inviting many underage guests to the party, and encouraging the underage guests to drink, especially an underage guest known to become belligerent when intoxicated, were intentional actions that violated the law. Gundrum's many intentional wrongful acts were a substantial factor in causing the plaintiff's bodily injury. Viewed from the standpoint of a reasonable insured, Gundrum's intentional actions created a direct risk of harm resulting in bodily injury, notwithstanding his lack of intent that a specific injury occur. Thus, the bodily injury was not caused by an occurrence within the meaning of the policy, and the insurer was not obligated to provide insurance coverage for Gundrum. Intent can be inferred in certain felonious assault or rape cases where the intentional acts necessarily cause harm. However, courts should be careful to avoid applying the doctrine in cases where the insured's intentional act will not necessarily result in the harm caused by that act. Almost any injury that one causes while driving under the influence of drugs or alcohol is foreseeable and arguably even substantially certain to occur, but an intent to cause those injuries is not generally inferred in such a situation because more than foreseeability or substantial certainty is required to infer an intent to cause injury. This video was adapted from my book, Zelma on Insurance Claims, Part 103, Second Edition, which is available as both a paperback and a Kindle book from Amazon.com. If you found this video to be of interest to you or your colleagues, please pass it on, and please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn of future videos and future blog postings. I'd also like to hear from you if you find this video and the others I've posted over the years to be useful and interesting to you. Please write to me at zelma@zelma.com. Thank you for your attention.